Now we'll move on to employment visas. So I'm going to talk you through the employment visa issued under the General Employment Policy. So there is an approvability test to get this visa, and the approvability test is that you need to demonstrate as an applicant for the status that you possess special skills, knowledge, or experience of value to and not readily available in Hong Kong. Moreover, the employer must be justified in engaging the services of an expatriate, sort of dimension that's in play throughout employment visas. And that is if the nature of the work is detailed on the talent list, which is part and parcel of the enhancement measures to immigration policy to seek to attract and retain certain qualities of talent to Hong Kong. If the job is on the talent list, for the most part, you don't need to prove that a local person can be expected to do the work. The talent list gets augmented from time to time, and on the clickable links that I showed you at the outset of the presentation, you'll be able to access the talent list and understand whether or not the nature of the work in question requires a need to test the local labour market. So that's just one other sort of enhancement measure thing that's hanging around as a result of enhancements to immigration policy over the last couple of years, really, all things considered. The definition of a professional is that you are a university degree holder, you are a university degree holder and you have a minimum of 2 years post-graduation working experience in a managerial or supervisory capacity, or you're a vocational graduate, so you've got a technical or a trade qualification, and then you have a minimum of 5 years post-qualification experience in a managerial or supervisory capacity. If you're a mere 18-year-old high school graduate, then to be deemed a professional, you need to have a minimum of 10 years post-secondary experience in a managerial or supervisory capacity. Now, if you are merely a high school graduate, my experience has been that very difficult to expect approval if you're any younger than sort of 32 or 33 years of age. Not impossible, but the Immigration Department generally ascribe professional status to those folks who have gone through the discipline of a formal post-secondary education, either at the vocational level or at the university graduate level. And in terms of how the Immigration Department deem applicants for employment visa status, there are kind of like what I call sort of 3 particular types or qualities of applicant. And depending on the type or quality of the applicant, you've got what I call the administrative or the argumentative axis. So on the one hand, if you sit on the administrative axis, you don't have to worry too much about having a really compelling argument. But on the other hand, if you don't sit easily as regards expected approval because of the circumstances that the applicant finds themselves in, you're going to have to argue hard for the approval. Now, these are just broad sort of break it down into sort of 3 bucket type scenarios. The Immigration Department don't recognize these in any sort of formal sense, but having done tens and tens and tens and tens and tens of thousands of cases down the years, you get a sense of sort of how it all lies. So broadly, well, as long as you're anticipating how this sits within the context of the approval criteria and the approvability test as a professional, if you're an intercompany transferee, generally speaking, the Immigration Department are not going to look askance at the rationale for the visa in a situation like this, and they're not generally going to be too concerned if there has not been a local recruitment exercise promulgated for this particular role in question. On the other hand, if you're in Hong Kong as a employment visa holder sponsored by another employer and the employer seeking to hire a local recruited expat, then the Immigration Department want to know why are you hiring this expat? So you've got to sort of argue your case stridently. And of course, be ready to satisfy the Immigration Department that genuine efforts have been made to seek to find a local person to do this role that is ostensibly going to be uptaken by the foreign national on a change of sponsorship basis. And then if there's been kind of a headhunted, out of the blue, specifically recruited expat from overseas, then the Immigration Department are going to apply the test for approval very, very stringently against the applicant. Just because they apply it stringently doesn't mean they won't get approved, but you need to sort of appreciate that if you treat a specifically recruited expat from overseas as an administrative case, unless it's a really, really senior case, and you don't engage in too much argument, then you might find yourself in grief winning the day with the department. So basically, you got to sort of, weigh it all up and put your best foot forward, knowing that there are these kind of three buckets that generally present themselves, and how hard you have to work in each particular type. So those are what I've called the three types of applicants. So other things to consider as you're working your way through the employment visa process: the sponsorship form, ID 990B, really requires you to demonstrate that genuine efforts have been made to seek to find a local person. And if you aren't able to put evidence forward that genuine efforts have been made to find a local candidate for the role, then you have to write a letter of explanation as to why that is. So they're seeking to address the justified limb of the approvability test through that part of the ID 99B sponsorship process. New companies, if the business is new, it's going to be tested as a valid sponsor. And so the rule is that to be deemed a suitable and credible sponsor of an employment visa in Hong Kong, the sponsor must be, quote, well established, unquote. So being well established means that the entity has been in existence for a minimum of 12 months, trading in all of this time, ideally profitably, has a properly set up office, is already an employer of Hong Kong locals, and has sufficient financial means to be able to meet the financial commitments as they fall due, and also to be able to successfully engage the foreign national, if approved, in the job that the company is seeking to serve as sponsor for. Generally speaking, if you are less than 12 months, it's not impossible to be deemed a suitable and credible sponsor. It just means that the Immigration Department are going to look to see what the plan is for the enterprise, and that the suitable contribution to the economy of Hong Kong that's generally found within the business investment visa as an entrepreneur, which is a substantial contribution to the economy of Hong Kong. All of that can be addressed positively in order to acquire suitable and credible sponsorship status. So not impossible, but it's two tests that you need to satisfy. A test for the employee, special skills, knowledge and experience of value are not really available in Hong Kong, and being a professional to boot. And also the sponsor needs to be able to show that they can contribute substantially to the economy of Hong Kong if they're not well established as defined. It is possible to change from visitor to employment while you're in Hong Kong. The Immigration Department don't insist that an applicant for an employment visa be physically outside of Hong Kong on the day that the application for employment status is submitted, but it is an entry visa, and the visitor status that the applicant holds and the application for the employment visa are independent variables. So an applicant that's here as a visitor will still need to manage their visitor status while the application for an entry employment visa is in process. And you can't use the fact of an active application for an employment visa in the system at the Immigration Department as a means to get an extension to your visitor visa. So whilst it is possible, you need to manage the visitor status separately from the employment visa application. And once again, you can apply to change your employer in Hong Kong if you hold an employment visa. It's colloquially known as a change of sponsorship application. It is not permitted to take up any employment duties until and unless the change of employer application has been finalized positively by the Immigration Department. So in essence, if an applicant for change of employer has already resigned from his current job or her current job, then they're expected to basically sit and wait the Immigration Department's final determination of their application to be able to take up their duties once approved. As a general rule, if the applicant's current employment visa limit of stay is going to expire sometime in the next 12 months, then the Immigration Department will grant an extension to their existing limit of stay, generally for 2 years on top of the remaining limit of stay that they've got. So they will entertain both an application for extension of stay and change of employer at the same time. But if you've got 2 years or more left, generally, the approval just comes in the form of an approval letter denoting the date when the existing limit of stay is going to expire, and then they will be expected to seek to extend that visa within 4 weeks of that expiry date listed on the approval letter in that regard. So the top tier status, which I will come to, creates the potential for a top earner in Hong Kong that has earned $2 million in the year prior to submitting the application for a change of employment. If they have acquired top tier status, then all conditions are removed but to the limit of stay, which avails a 6-year extension. And in those instances, if you have an employment with an employer that you worked for, that you qualify for top tier status under, and then you leave that employer whilst you're holding top tier status, you do not need to formally apply to change your employment visa sponsorship. What you need to do is to notify the Immigration Department within 30 days of your new employer, and that's a mere notification exercise rather than a permission in advance exercise. But I'll talk about the top tier status in a little while. Okay, so very often the question is begged as to, if you own your own company, can you get yourself an employment visa? Well, the general rule is that you can't self-sponsor. The expectation is that the sponsoring entity is going to be different from you. On the other hand, if you're an investor and you own 50% or more of the shares in your employer, generally you can apply for an employment visa as long as the sponsoring entity is a well-established entity. That would mean that you go through the process of proving that you possess special skills, knowledge, and experience of value to and not readily available in Hong Kong, rather than, as you would have to, as we'll see subsequently when we come to the visa type, demonstrate that as a business investment visa applicant, as an entrepreneur, you can contribute substantial to the economy of Hong Kong. So the expectation is that if you're going to seek to work for an entity that you own 50% of, then that business needs to be a well-established company in its own right, which, again, to repeat, is that it's been in existence for a minimum of 12 months, already an employer of Hong Kong locals, has a proper set-up office, been trading in the 12 months since it's been in existence, ideally profitably, and it's got sufficient financial resources to be able to successfully complete the employment that's underpinning the application for the visa and for the visa in the first place. So quite often what will happen is that clients will, say, well, I've just incorporated this company. I want a friend of mine to sort of take 50% of the business so then I can go through the process of avoiding a business investment visa as an entrepreneur application and just go for an out-and-out employment visa because otherwise I'm a professional. And sometimes even they might use a nominee to this end. In the final analysis, the Immigration Department, they tend to lift up all the rocks and they tend to want to know what's going on. So, you can't really pull the wool over their eyes. So you're much better off just avoiding all sort of nominee arrangements if there's, an intent to try and, skirt around the, let's say, challenges associated with the various visa types. And just, go to the Immigration Department as an honest broker and say, look, this is what's going on. This is what I'm all about. And then you'll know pretty quickly whether you should be applying for business investment visas as an entrepreneur or whether you're going to be in good stead to pursue an employment visa as a professional in those circumstances. So this is kind of the grey area in relation to being an owner-employee. In the final analysis, whichever way, you tell your story and the argument you put forward, if it's worthy of approval, you're going to get the approval. So as I mentioned in a couple of slides earlier, if you're a top tier stream employment visa holder, it kind of goes like this. So it was an enhancement measure which was introduced to attract and retain entrepreneurs, professionals and talents, whereby if you've had 2 million Hong Kong dollar assessable income in the 12 months prior to making an application for top tier employee status, what you can do is you can go to the immigration department and show that you're still working for your original sponsoring employer, that you got a minimum of a 2-year visa at the time that you applied for top tier status, that you're still working for that company, and that you earn $2 million as evidenced by your basically your tax bill. If you've got all that in play, you can take your application to the immigration department at any time during the 2-year visa that you hold and seek to have all conditions removed to your present status, but for the condition associated with limit of stay. And so assuming that you've got still 6 months validity in your passport, they will grant you 2 years on top of the limit of stay that you've already got, and then they will cancel the need for sponsorship and convert the requirement to seek pro forma permission to change employers, as I mentioned earlier, into an after-the-fact notification to the immigration department within 30 days of having changed your employer, including having yourself as an employer, which means that you can, under this status, go from sponsored employment visa through to functional entrepreneur, business investment visas and entrepreneur status, because you would then simply notify the immigration department once you leave your sponsoring employer that you're now working for a new employer. And because it's a mere notification exercise only, that employer can be your own entity. And so it's a ticket to ride, as I've said here, because you get an immediate 6-year limit of stay, and you don't have to worry about sponsorship anytime after this. So if you're a top earner, then money counts, and it's a great way for folks to move from sponsored employment through to a visa category that's going to give them unlimited potential. And I'll give you an example that I've got in play at the moment with a client where this is going to prove to be significantly beneficial. So she is presently working for a Hong Kong for a Hong Kong employer. That Hong Kong employer is actually owned by her family overseas. The family business overseas is undergoing a sale at the moment, and they're going to cut the Hong Kong company loose. So they're going to transfer the shares into the name of the employee, and she's going to pay herself 2 million Hong Kong dollars. We're going to get her top tier status. And then once she's secured top tier status, she's going to wind the company up. And she will procure a new passport in the meantime. And she's still got 2.5 years left on her existing employment visa. And we'll get her 6 years. So she'll end up with basically 8.5 years under top tier status, to give her all the flexibility that she needs to do what she wants to do over, what the best part of it, well, just short of a decade, I suppose. And it's all perfectly lawful. It's just that, the circumstances in the way that her employment was manifested, the pending sale of the family business overseas and Hong Kong being cut loose as part of that transaction anyway, creates the conditions for her to get what will ultimately be sort of a total 9-year period of stay. You need to be a professional